Okay, so we're back for part two of a Protect Your Neck clip, discussing property values and property law, and how you can be sure that you are protecting your property and what happens to your family's property as individuals begin to pass on right wills and the heirs of a property. So one of the first things I want to talk about that I briefly mentioned in the last video is about the terms joint tenancy in common, and then you have joint tenancy with right of survivorship. So I want to first start with talking about joint tenancy with right of survivorship, because that's usually the one where our property interest or possibility of a property being passed down to us starts. It starts with your parents or your grandparents as married couples. Most often, joint tenancy with right of survivorship is what happens between a married couple, and ultimately it is a legal term, okay? And so because joint tenancy with right of survivorship is a legal term, it generally overrides a will. So what ultimately needs to be known is, say for instance, your parents have purchased a house together, and we'll talk about the different requirements that are necessary for something to be considered joint tenancy with right of survivorship. But say for instance your parents purchase a home together, and they have children. They have you and your siblings within their marriage. However, your mom has another child or your dad has another child outside of the marriage that they had before the marriage. What joint tenancy with right of survivorship does is, if for instance that dad who had a child outside of the marriage, or that mom who had a child outside of the marriage passes away, the property cannot be passed to their heirs. The property value, the percentage of that individual's property right passes to the surviving spouse. So, for instance, if your mom and dad purchased a home, they each get 50% joint tenancy in their home with right of survivorship. The right of survivorship says that the surviving individual has the right to everything that is attached to that property when the other party passes away. So their 50% will turn into 100%, and 100% of that goes to the surviving individual. Now, what that also means, like I said, is that it cannot be passed down to someone in an heir that is for one of the survivors if there is still a survivor existing. However, when that survivor passes away, then it is likely that the property, hopefully, is in their will or in their beneficiary documents, and it passes to the heirs at that point. Now, there are specific requirements around what has to be done in order for a property to be considered a joint tenancy with right of survivorship. And ultimately, some of the things that have to be done when you have joint tenancy with right of survivorship is that the individuals that have the interest in that property, they must have acquired the property on the same title. And so it can't be that I purchased the property and then years later you purchased the property, and so we have separate titles. They have to be on the same title for the property. They also have to have given or paid for an equal share of the total assets in the property. And so that's where that 50% comes from. And then each of them must each have the same right to possess the entire asset of the property. So what that means is that even though we split the percentage of the property, you have 50%, I have 50%, we have 100% rights in the property. And so when one of the individuals in that property passes away, those rights passes with the percentage to the surviving spouse, giving them 100% of the percentage in the property. In most states, that is what must happen in order for it to be recognized as a joint tenancy with right of survivorship. And so the other thing is that this, because it is a legal recognition and representation of the laws around property, it has to be clear that this is a joint tenancy with right of survivorship. And so usually an attorney or an estate planner should assist you with the wording, and the wording should clearly state that this is a joint tenant with rights of survivorship and not a tenant in common situation, because a tenants in common situation is very different from a joint tenancy with right of survivorship. And so what ultimately happens with that joint tenancy of right of survivorship is that it automatically means that the individuals have a tenancy in common process happening in certain jurisdictions. And so when that person again passes away, ultimately what occurs is that they gain all of the percentages as a legal right. And so what that also means is that the joint tenancy with right of survivorship overrides a will. Okay. And so most times married couples are primarily by default in what is known as a joint tenancy with right of survivorship. But there are times when you have what is known as a tenancy in common, and they do not have the same legal rights. And so what the tenancy in common means is that when a tenant passes away that has rights in a property, their rights automatically pass to an heir or beneficiary that they have chosen. And so again, the difference between the right of survivorship and the tenancy in common is that when the right of survivorship happens, the surviving individual acquires 100% of the property, versus with the tenancy in common, when an individual passes away that owned a percentage, their percentage passes to whoever they have identified as their heir or beneficiary to the property. And so you don't generally have to have an equal stake like you do with right of survivorship. With a tenancy in common, you can have varying percentages. So for instance, you may have 50% of the property, and then your remaining siblings or cousins or whoever else has been identified as an heir may have 15% or 25%. As long as the percentage equals to 100, whoever is identified, they have that 100% share. Now, what can happen in that situation with tenancy in common is that individuals, if they sell their shares to a third party, they break up the tenancy in common and it no longer exists. And so as soon as an individual does that, because a tenancy in common is not automatically considered a legal document like the joint tenancy with right of survivorship is, there are many ways that an individual can terminate the tenancy in common by the actions that they participate in. So one of it is, you can buy a person out of the property. You can also sell your asset, i.e. selling it to a third party, or you sell your stake in the property. And so you got to be really mindful. This is where it gets tricky, because a lot of the predatory realtor companies and the predatory corporations, this is how they are terminating families' automatic tenancy in common where there were percentages, is because they are getting individuals or heirs or beneficiaries who have percentage to sell their percentage to them. And once that individual sells their percentage to them, the tenancy in common that you owned automatically is terminated. And it also does not technically override a will. A will does not technically automatically override it. So with a joint tenancy with right of survivorship, it overrides a will automatically because it is considered a legal document. However, depending on what state it is in, or whether or not the person even probated their will or recorded their will, or even if the deed is not properly recorded or effectively recorded, this is where we are getting into the weeds of losing our property, because we're not recognizing that as soon as a stake or a percentage is sold in the property that has been heired to us, it terminates the tenancy in common. So there are things that we need to do to safeguard and make sure that this doesn't happen. One of those things is making sure that the deed, once it becomes known that the two individuals who originally owned the property are no longer surviving, that the deed is transferred to the names of the individuals who own the property and is recorded effectively. This is really important because, like I mentioned before, there are some states who have different types of notices around the recording of a deed. Some other factors are about putting documentation in place about the collective agreement of an individual being able to sell their property before they do so. And so the next video will dig into putting those safeguards in place to protect your property